Thank you, Mr Deputy Speaker. I propose to speak very briefly. I only have one substantive point of principle to make. But before I get to that, I'll start by saying to the Leader of the House, I commend him again for taking on board the concerns of all sides of the House, or both sides of the House, and for the approach he's taken to this. I have as much taste for political combat as the next man, but I think the tenor of this debate, and I say this to all my unionist colleagues on all sides of the House, the tenor of this debate matters almost as much as the content in terms of not generating grievance and nationalist causes, shall we say, as a direct result of our attempt to stabilise our constitution. Now, that being said, I will take issue with the government over the approach of using standing orders. The simple argument given to me at the beginning of this was that this was to protect any change from interference by the courts. Now, whilst I understand this argument would have applied equally to the 5-year Parliament bill, for example. And yet that was capable of being drafted in such a way that the courts wouldn't dare meddle in it, as I think the courts would not dare meddle in this. Whatever the legal position, the political position of our courts is they would not interfere in something as fundamental as the balance of power between the parts of the Union. And so I view that as really very serious, because it takes out of play in this, in what is a constitutional ruling, it takes out of play the House of Lords, it takes out of play the whole mechanism that we normally apply to this. So we are in a peculiar position of having a constitutional change to our House of Commons, which is put in very quickly with probably not enough consideration, and by a future government can be taken out equally quickly. And that's, in many ways, even more dangerous than the mechanism we've chosen. So, that being said, we
are... Right honourable friend give way?
Yes, I will, but I want to be brief. So, yeah.
I'm grateful to my right honourable friend, but that is one of the strengths, I think, of using standing orders. The very fragility of it means that, contrary to the constant use of partisan by the honourable lady opposite, this will need to have consensus across the House, and at any election, any party would be asked whether they felt that this had become a settled will and the right way to run things, and if it did not, legislation could indeed be passed, and the Leader of the House, I know, has said that when the review is conducted in a year or so's time, that would be one of the options that would be looked at.
Well, I couldn't disagree with him more. The simple truth is that we have made it down the centuries with an unwritten constitution which has existed because of the respect given to it by both sides of the House. That has fragmented in the last decade or two, and I do not want to have a circumstance where the rules of operation which affect the democratic rights of our citizens, and by the way, we've been talking all the time about the democratic rights or the standards of MPs and whether we have one or two classes of MPs. What matters is we have one class of citizens. That's the issue. And I do not want that to be subject to the vagary of any government in the future. So I'm afraid I disagree with him. I wanted to keep this brief, but I will give way to him, of course.
Point, and I'm not going to touch on this in my speech, and I'm really pleased that the honourable gentleman's picked this up, and this is the whole issue of legal challenge. Now, the reason that we're having speaker certifications of post-legislation is to put it beyond legal challenge. So there's going to be no opportunity for the citizens that he describes to challenge decisions that are made in this House. Surely he, as somebody who takes an interest in this, must think this is thoroughly wrong.
Wrong for the reasons I've described, and I also, as he well knows, I take the view that governments should be subject to the law of the land and subject to courts. I'm less happy with the idea that the courts could rewrite our constitution the way which we don't see fit. No, forgive me, I'm going to try to make some progress on from this, if you'll forgive me. I give way, whatever he was saying.
I was merely... I'm most grateful. No, it's just that in the Scotland Act itself, there is already provision for judicial review where there is a question of ultra vires, where the boundaries on the question of whether it's a devolved function or not are actually under dispute. So the courts are already involved.
Yeah, well, the rest of the case. Now, let me make some progress, because the next point I want to make... I suddenly find myself in a courtroom rather than a chamber. There we go, I give way.
I was going to make this point later, but I might as well make it now, because this is the purpose of debate. Yeah. I mean, I have to say that I do have some slight anxiety about the justiciability of measures that we take in this House. I appreciate Article 9 of the Bill of Rights, but we are certainly moving, I think, into rather uncharted territory And I don't think we can rule out that a legal challenge might not be brought to decisions that are made on the Speaker's certificate.
Okay. Well, the House will take that on board. The other thing I would say to the Leader of the House in terms of what he's done so far is I commend him again on at least attempting to address the problem of the Barnett consequentials. Now, it's very important for a point I'm going to finish on, but this problem started in 1998. I guess the member for Gordon will remember, nobody else in the House would have reason to remember, that in 1998 I argued for fiscal autonomy for the new Scottish Parliament, for a more federal solution, for a proper treatment of the West Lothian question. All of these things were self-evident in 1998 as a long-term problem for the devolution proposal. And I have to say to the opposition front bench, we were received with a complete implacable lack of understanding, let alone lack of sympathy from the primary driver, I think, of that, which was Gordon Brown in those days. But it comes from the confusion of what we have in terms of the current Scotland Act and the Scotland Bill that's going through at the moment. Because that bill failed to create, in my view, what would have been a stable fiscal autonomy for the current Holyrood Parliament. If it had done so, it would have separated out the funding streams for the Parliament spending and for the spending that emanates from here. Had that been done, then we would have had very, very few, if any, Barnett consequentials. Now, of course, it won't solve everything. I mean, the member for Gordon quite rightly raised the point of other impacts of tuition fees and so on. There's going to be tax competition between the parts of the United Kingdom. There's going to be competition between policies of various sorts. You cannot resolve all of that. And you cannot give to the Scottish members necessarily some sort of veto over England's right to do the best for its own citizens. So this is not entirely soluble, but it would have been much more soluble if we had written that Scotland Bill in such a way that it created a more rational structure than what is taking place in our kingdom at the moment. So all of this gives us a problematic issue and gives the Leader of the House a problematic issue in how he manages to do this with utter fairness to all sides. Because that's the test, utter fairness to all sides. And I'm afraid the British establishment has always seemed to have a preference for fudge rather than clarity, for ambiguity rather than logic. And we see this written through all of this constitutional area at the moment, and partly because the establishment doesn't want to address things, doesn't want to have an English First Minister that is more powerful than the UK Prime Minister. And yet, of course, if we went down a proper route of English devolution, if that's what it is, it would end up with an English government, which would then be a challenge to the UK government. So my only point of principle I'm going to make to the Leader of the House, given that he's now given us the summer to think about this, and we can deliberate at great length, hopefully, about it before we return in September, and he hopefully will take on board what he hears today, is the test of this is very simple. It's not whether it creates two classes of MP, it's whether it creates two classes of citizen. It's whether it deals with and removes any prospective grievance, not from the members on those benches or these benches, but from the people we represent. It should take away any grievance for the English and any grievance for the Scots and any grievance for the Welsh and any grievance for the Northern Irish. Not any grievance for the Labour Party or the Conservative Party or the SNP or the Liberals, but our citizens first. That's the test he should apply.